welcome everyone. Just so excited that you took out time to join us in this beautiful, sunny 70-degree weather. So thank you so much. I know you're juggling a lot, and we are just really grateful for you to carve out time to be with us this evening. My name is Courtney Chappell. I use she, her pronouns. I'm the advocacy director, and I'm part of the shared leadership team at Legal Voice, and I'm calling in from Seattle, the unceded lands of the Coast Salish, and specifically the Duwamish people. We just wanted to have a really informal conversation about everything that happened during this short, fast 60 days. A number of our priorities made it through, and a few others kind of failed to make the cut. And we just wanted to share with our community how some of these conversations and strategies unfolded, where we landed, and how we have really intentionally shifted in our advocacy to center community and our race equity values. And then also just share a little bit about what we're thinking about for 2023, because it's never too early to start plotting. So I'm going to just let our staff introduce themselves, just your name, pronouns, Indigenous lands in which you're calling from, and if you had to use one word to describe the session, what would it be? So who would like to go first? Andrew, would you like to go first? Just introductions.
Andrew Kashyap, and I use he, him, his pronouns. I'm speaking to you from the unceded Coast Salish, Stillaguamish, Duwamish, Muckleshoot, and Suquamish territories. And I'm focused on our economic justice work. And one word?
Yeah.
There was progress.
Good. Yeah, that's great. Catherine, would you like to introduce yourself as well?
Sure, thank you, Courtney. My name is Catherine West. I use she, her pronouns. I'm a staff attorney at Legal Voice. It's a pleasure to be in community with you on this beautiful day. And one word to describe the session. It was inspiring. I will say that. Inspiring. Kim, do you want to go next?
Yes. Oops. Hi, I'm Kim Clark. I use she, her pronouns. I'm a senior attorney for reproductive rights, health, and justice. And I'm actually calling in from LA, which is on the land of the Gabrielino Tongva people, the original caretakers of the Los Angeles Basin. And I'll
one word to describe the session.
Mixed.
Great. Thanks, Kim. And Jen, do you want to do a quick introduction?
Sure. Hi, folks. My name is Jen Martinez. My pronouns are she, hers, and Aya, and I am coming at you from Olympia, which are the unceded territories of the Nisqually, Coast Salish, Cowlitz, and Squaxin tribes. And one word to describe this session for me. Well, first, I'm the senior communications and marketing manager, so my role is very different from everyone else's. So my word is whirlwind. But happy to be here with all of you. And please introduce yourselves in the chat and where you're coming from so we get to know who you are as well.
Great. Thanks, Jen. So we're just going to go ahead and get started with our wrap up. And also, as you're kind of dropping your name, pronouns, where you're calling in from, if you have questions or specific issues that you hope that we'll touch upon, please add that into the chat as well, and we'll try to incorporate that throughout the conversation. So why don't we just dig right in? And Andrew, would you like to start? And I know you worked on a number of kind of safety nets, healthcare efforts aimed at supporting immigrants, and Legal Voice took like a leadership role in some broader bills that really expand employment protection. So take it away, Andrew.
Okay, thanks, Courtney. Yeah, so as I said, I'm an attorney focused on our economic justice work. And that means I'm focused on low-wage industries that women and LGBTQ plus workers are concentrated in, and that BIPOC and immigrant women disproportionately work in, like domestic work and restaurant work and farm work. And our underlying philosophy guiding that work is a community-based perspective we call community lawyering. Maybe some of you have heard us talk about that before, but for shorthand, that kind of means grounding our policy work in the leadership of BIPOC and other marginalized communities and their vision of what their communities need for their well-being. And I'm going to talk about 4 of our economic justice priorities in the 2022 session and how they came out. And it's a situation of sort of 2 pairs, 2 efforts grouped together well in a theme, and the other 2 also are different themes. So one theme that Courtney referenced is the safety net for undocumented workers. That's still very much in the midst of the negative COVID impact. There was a campaign to provide health insurance for undocumented people, and also a campaign to provide unemployment insurance for undocumented workers. And the other theme is advancing gender justice in the workplace through 2 victorious bills, one that bans non-disclosure agreements in Washington, the other that mandates disclosure of salary ranges by employers in job ads and postings. So I'm going to talk about those 2. And first I'll talk about the work that prioritizes the safety net for undocumented workers. And I just want to quickly frame that work in the COVID context in which it's grounded. Low-wage workers that we focus on are mostly in service sector jobs, and workers in those jobs are disproportionately women and BIPOC immigrants and LGBTQ+, and also disproportionately undocumented. And there's a disconnect now that we can see occurring between the recovery narrative that's emerging in the media and the reality for these workers that, continues really to render those workers invisible. While in Idaho and Washington and many other states, COVID cases appear to be on a pretty steady downward trend, and nationally, the narrative is about an upward economic trend amidst signs like jobs coming back. That narrative really overlooks the ongoing economic devastation in these communities before the pandemic, and now that they're facing even more dire circumstances after the pandemic. That's reduced job opportunities, while also threatening their health. And workers are put in the catch-22 of choosing income or their own health or caring for their families, given the lack of benefits they have compared to higher wage workers in a world where 35% of low wage workers have paid sick leave, while 95% of high wage workers do. So amidst that disparity, we're focused on policy solutions that center equity, and that the low wage worker groups that we work with, like domestic worker and hotel worker groups, those solutions that they're calling for. And that's shaped a couple of key parts to our legislative work in the 2022 session. The first one is that campaign for healthcare for undocumented people. There are over 270,000 undocumented immigrants in Washington state. A survey in 2020 showed that nearly 90% of them lack health insurance. And that's because while Medicare and Obamacare have filled the gap for many low-wage people, still undocumented communities remain a gap population in that healthcare system because they're ineligible for both those programs due to immigration status. So that's really a human rights tragedy in this country amidst COVID, and it's critical not just as a basic human right, but also as a matter of public health that undocumented people have access to health insurance. So this campaign's vision of that is the same coverage for U.S. citizens as U.S. citizens and others receive that those who don't have immigration status should get. So that means Medicaid-like coverage for people with lowest incomes, and also access to the health benefit exchange programs for those with incomes that are just above that lowest level. So that goes up to 250% of the federal poverty level. So the campaign started last year with a proviso that we won that called upon the state to establish healthcare coverage by 2024. And this year in the 2022 session, the strategy was again to focus on the budget and get a significant financial commitment, a down payment essentially from the governor and the legislature towards the cost of the program. And we won. We got a $12 million commitment in the budget towards the cost of setting up the program. And the budget also committed a pathway to funding the health coverage costs for both parts of the program, both the Medicaid lookalike part and the health benefits exchange part in next year's budget. So in the 2023 budget. So we're on track to start the program still by 2024. And we've moved one more step forward, and we're going to continue our advocacy in the 2023 session to get that next big funding commitment to establish the program by January 2024. So that's our first campaign I wanted to talk about. And the second one was the unemployment insurance for undocumented campaign. And that's another key part of the safety net, of course. And undocumented people are again excluded from this key benefit because documented status is required for unemployment insurance, both under federal and state law. And this, of course, has had devastating consequences during the pandemic, which showed what a vital benefit unemployment insurance is. Washington workers were surviving on their unemployment checks, and we know the system paid out about $10 billion to Washington workers during that heavy COVID period in 2020-21. And our community might recall that last year we were pursuing this bill for creating a UI program for undocumented people, and still no program like it. There's no program under statute in any of the 50 states. New York has come the closest, like us. But this effort didn't come to fruition this year in our legislative session. We drafted a bill, but it again stalled in the Senate Labor Committee. And unfortunately, that happened again. So it's a big funding ask for one, and it shows the difficulty of getting the issues affecting large but marginalized communities elevated. And it could be that the midterm elections had something to do with that. So we're beginning to strategize early for next year and bringing this bill back. In the meantime, though, there is about to be rolled out a $340 million relief fund funded by the state and by the Biden recovery bill. So at least there's something for undocumented folks left on the horizon, though it's not enough. So that's our two pieces to undocumented safety network. Next, I wanted to mention the Advancing Gender Justice in the Workplace bill. So we had two important successes that put Washington on the map, with only a few states across the country that have established both those rights. One is in line with the legislative solutions that follow from the Me Too movement to combat sexual harassment and violence in the workplace. And that's House Bill 1795 that passed, which bans non-disclosure agreements, or NDAs as they're called for short. It bans them in the workplace. So NDAs are agreements that employers, abusing their unequal power and leverage, force employees to sign either as a condition of getting hired or to get a settlement when employees have brought complaints and lawsuits about harassment and discrimination and other types of illegal conduct. And an employer then uses their leverage to force an employee to sign an NDA in order to get a settlement. So NDAs have been used for decades by employers to make employees remain silent about the harassment or other mistreatment they've suffered. The employee can't disclose anything about the case to any other person ever under an NDA. They're forced into silence. And if the employee does speak, they're penalized by having to pay money to the employer. So this was a really important victory in the march toward changing workplace culture related to sexual and racial harassment. Now employees will be able, if they choose to talk about their experiences of mistreatment, whether to a coworker, experiencing discrimination in the same workplace, or to an investigator investigating that workplace, or a family member or friend so they can provide support, or to the media to choose to alert the general public. And while we helped pass a first step version of this law just after Me Too in 2018, that made NDAs invalid as a condition of employment, this bill goes the next step and covers where we see this problem the most, which is in settlements. So that's a really important victory. And for low-wage workers and BIPOC and marginalized communities, this is an important bill in that way because it leaves no exceptions. Employers often misuse those exceptions against workers where they have the greatest power imbalances. So in that way, the bill is sending a broad message of deterrence and signaling to employers that the era of transparency and culture shift is really here to stay. So that's an important bill that passed, an important victory. And finally, similarly toward culture shift in advancing gender justice at work, we participated in a successful effort to pass Senate Bill 5761, and that bill mandates that the wage scale or salary range of a job and a description of all the benefits and other compensation of the job must be contained in any job posting. So this bill is really important for the equal pay movement and helps reduce the possibility of equal pay violations. And you might remember that we passed a bill a few years ago on the same issue that placed restrictions on employers that in terms of inquiring about prior wage or salary history of a worker, and that required employers to disclose minimum wage or salary of a position to a worker upon the worker's request after a job offer had been made. That was all the conditions of that bill. So this bill improves upon that bill. Now the wage and salary information must be provided early, right from the start of the job process through the ad, instead of after an offer of employment has been made or a worker has to request it. And plus now the wage and salary range information and all the benefits must be provided instead of simply the minimum pay. So that range is another really important add. And this bill was led by Senator Emily Randall and based on a model law in Colorado, the first state to require salary ranges to be in job postings. So that was a victory, and it shows how we're engaged in what's really an ongoing strategy to refine our efforts to eliminate equal pay violations. And we know that's a multi-pronged effort, and no one strategy alone is a magic tool. So we're engaged in that ongoing work to shore up equal pay. So that's the strategy. So I'm going to stop there until we get to the looking ahead to next year piece, and I'll stop there and pass it back to you, Courtney.
That sounds great. Thanks, Andrew. I'm going to turn things to Catherine, right, to talk about Catherine worked on just a variety of different bills. Bills that support the trans community, domestic violence, sexual assault bills, efforts to really provide opportunities for underrepresented community members to serve on just boards, committees, and a few other things. So Catherine, want to take it away?
Thanks, Courtney. So first I want to talk about a bill 1956, which was a nice pivot from what was going on across the country with regard to trans and non-binary people. So as we all know, there's been a national assault against trans youth, trans adults nationwide, and it's been very troubling and scary to watch. So in contrast to that, that effort by conservative groups, a small coalition of community groups came together to advance a bill that would protect sensitive information of folks who are incarcerated from being available for public records disclosure. And the idea was that folks who go into correctional facilities retain their dignity, their rights. And so when they go back out into the community, that their detailed health, gender identity, sexual orientation information should not be made available to the general public. And we know that when some folks have their information released into the public, that harm and harassment can come to them. And so this was really a way to help protect them from harassment and be able to rejoin the community. I'm really hoping you can't hear this old dog that's panting in my ear right now. I'm hoping that's just coming at me and not at the rest of you. But another community coalition was 1961, which was a bill to require that a fee associated with name changes could be waived by the district court. So trans and non-binary people, as part of a social gender transition, often seek to change their name. And that process can be, for many trans and non-binary folks, quite expensive and also difficult to navigate. And part of that was because there's a fee both to file the case in court, but there was also a mandatory fee to pay to the auditor's office so that that name change gets filed in public record. And many of us in the legal field know that low-income people have the right to seek a fee waiver for filing cases in court. And so low-income folks seeking a name change were able to do that. But then there was still kind of an open question about whether this auditor fee could also be waived by through that same process. And this bill clarifies that yes, in fact, it should be waived by the district court for low-income people. And although it seems like, just kind of a tiny tweak, it's really makes a big difference in both advising clients about seeking a name change and the cost that's going to be associated, as well as for them to have actual access to a name change process. There was also a sexual assault nurse education bill that was very exciting. Up until this bill, Harborview had been the only program to train up sexual assault nurse educators called SANES, S-A-N-E. And so now the Washington State University is going to add additional training and programming. And the hope is that that will help fill the gap for rural survivors of sexual assault, so that there will be sufficient nurses who are able to conduct those very specific exams. There was another bill that actually didn't make it, but had a good ending outcome, which was 5551. That was a bill, seemed like a very common sense bill that was going to pass without any problem. But that was not the path of this bill. It was to require the healthcare authority, which administers the Medicaid program in Washington State, to require coverage of HIV antiviral medication without a prior authorization. And so for people who are able to navigate healthcare systems, you know, seeking a prior authorization is typically not that problematic, but for folks living houseless or with mental health issues or other barriers, going through that process just to get the medication that you need in order to be healthy and well and prevent future transmission of HIV was, you know, is a problem. And I'm sad to say that that bill did not move forward and was going to die. But actually, the coalition that brought it was able to move and pivot to have it included in the state budget, which is good. That's a good outcome. The unfortunate part is that that means that the coverage only starts as of January 1st, and because the budget ends in June, it's really only 6 months of coverage, which the coalition is hopeful will mean that the healthcare authority will then voluntarily agree to offer those antiviral medications without prior authorization going forward. But if they do not, there's a coalition of folks that are going to come together to strongly advocate for, again, a very common sense measure. The next thing I'll talk about is 5793. This is a really exciting opportunity. It will provide stipends for low-income folks and folks who come from the communities that are marginalized and underrepresented, about whom often recommendations are made in councils, task forces, other sort of bodies. And the idea is that the people closest to the problem should be present and in leadership roles around making recommendations for those communities. But up until now, there had been no mechanism to pay those individuals for that labor. So this is a new program. There'll be rulemaking around how that will exactly work. But the hope is that this will allow more representative individuals to be participating in leadership and decision-making around the policies that govern their lives. So stay tuned on that. There'll be more to say as we learn more. And then finally, many folks know there was a pretty major rewrite of the protection order statutes last session. They went back in and did some additional changes to the protection order statute. And the one piece that I just want to uplift is the inclusion of coercive control as part of a definition of domestic violence. This is the kind of behavior that many survivors experience, but had not been included as considered as domestic violence available for relief under the protection order statute. And so I'll just list off some of the types of coercive control that was included. Carrying a weapon to intimidate, driving recklessly with children, communicating with internet to harm children, harm someone's career. And then interestingly, it also includes engaging in vexatious litigation, which we know happens very frequently to survivors who are constantly called back into court as a means to harass and further control them, which is a bill that Legal Voice took up a couple of years ago. So it's very reassuring to see that that kind of abusive behavior was named in this bill as well, and is being curtailed further in this bill. Thank you.
Great. Thanks, Catherine. Okay, so we're going to pass things over to Kim to talk about the repro landscape locally, how Washington is really trying to protect reproductive health care, including abortion, and why that's important now more than ever, given all that's happening regionally and nationally, including in Idaho and Montana. So Kim?
Thank you, Courtney. Yeah, so obviously this is an area that is rapidly evolving. So I'm going to talk about 2 bills in Washington, but then I'm also going to give a little preview into what we're kind of anticipating going forward. So we worked really on 2 major bills this past session. The first, unfortunately, didn't go all the way. That's the Keep Our Care Act, and that's a statute that would have given the Attorney General's office oversight over hospital mergers, and it would have enabled the Attorney General's office to require that hospital mergers not result in a decline in affordable healthcare services, and in particular, reproductive health care, gender affirming care, and end-of-life care. One problem that we've seen nationally is that when hospitals consolidate, interestingly, whether or not they're Catholic hospitals or secular hospital systems, it's not uncommon to see a decline in access to affordable healthcare and those particular types of healthcare. And so this statute would have given the Attorney General's office authority to review those types of mergers before they happen, and to essentially disapprove of any merger that would have resulted in a decline in services. It's a complicated statute, and we worked with a large coalition of organizations to advocate for that bill. And the fight is definitely not over. It will be continuing next session and perhaps beyond that. But unfortunately, we could not get it past the finish line this session. The second bill, though, that we worked on this session was House Bill 1851, which amends and this bill was successful, and it amends the Reproductive Privacy Act, which is the statute in Washington that protects access to abortion care and basically codifies the standards set forth in Roe versus Wade. This amends that statute to affirm that advanced practice clinicians, which includes advanced registered nurse practitioners and physician's assistants, can provide abortion care. A lot of state statutes, including our own Reproductive Privacy Act, include these antiquated provisions that assume that licensed physicians will be the only providers who are eligible to provide abortion care. And that's because at the time that they were passed, the concern was ensuring that those providing the care, were doing so safely, and had the appropriate skills. But since that time, this whole new class of very skilled providers with advanced education and experience have come onto the scene, and they now are providing many of the services that licensed physicians used to provide, and whole communities are now really rely on advanced practice clinicians to provide the lion's share of their reproductive health and primary care services. And these clinicians provide care that is much more complicated than abortion. So this amendment is really just affirming what 2 Attorney General opinions in Washington had already held, which is that it would violate there would be no medical basis to preclude advanced registered nurse practitioners and physician's assistants from being able to provide abortion care. So it would violate both Washington law and the Washington Constitution to preclude them from doing so. So in that sense, this statute really does expand access to care. It also cleans up some of the very gendered language in the RPA. So great win there, particularly as the state of Washington is facing an onslaught of patients coming into the state from other neighboring states to access abortion care. And of course, that's because there's a case before the Supreme Court right now, and I'm sure I'm not telling anyone anything they don't already know, called Dobbs versus Jackson Women's Health Organization, in which the Supreme Court really is considering whether or not Roe v. Wade is still good law, and at least whether or not the viability line that was drawn in Roe versus Wade is still good law. And in anticipation of the outcome of that case, and really, there's really not a lot of disagreement among legal scholars that whatever happens in that case, it will, the Supreme Court is almost certain to, if not overturn Roe versus Wade altogether, really got access to abortion care to the point where it's essentially meaningless, and we're back to where we were before Roe versus Wade. So in anticipation of that decision, states across the country, as I'm sure everyone knows, have been passing very, restrictive abortion laws. I mean, even before the case is decided. And for example, Idaho just passed a statute that essentially is very similar to the statute that was passed in Texas, that the Supreme Court declined to review, which or to weigh in on, which enables individuals to bring private causes of action against abortion providers for procedures that they perform after embryonic cardiac activity can be detected, which is at about 5 to 6 weeks of pregnancy and before many people know that they're pregnant. So as a result of that Idaho statute and others like it that are being passed across the country, progressive states like Washington and Oregon are anticipating a huge uptick in pregnant people coming into the state from out of state to access abortion care. So going forward, obviously, advocates in progressive states are really thinking a lot about how to ensure, protect and expand access to care and address the needs of pregnant people who will be coming into the state to access care, whether that's, to provide additional funding, or as in the case of what we just did in Washington, expanding the pool of providers who can offer care. But looking at lots of different options, one of the things that's happening in Washington State now is that we are sort of co-creating a new coalition of advocates and individuals, across the region, actually, to advocate for expanded protections in the state of Washington and make recommendations to the Washington legislature, much like a group of organizations has done in California with their Future of Abortion Council, and there are similar coalitions forming in other parts of the country. But beyond ensuring expanded access to care, the other thing that we're concerned about is we know that states that are banning abortion now are not likely to stop, just with, ending abortion within their borders, but are likely to seek to assert jurisdiction over conduct that takes place either partially or entirely outside of their borders. And for those of you who are lawyers, you might say that doesn't seem like that should be constitutionally possible. The law is actually less well settled on that than you might think. And so advocates in progressive states are also now really looking at ways to protect their providers from claims by out-of-state litigants for conduct that takes place like within our state's borders. And there are lots of different solutions that are circulating nationally. We are in dialogue with other organizations in progressive state-based organizations in progressive states, and also national organizations to sort of think through, what protections might be necessary for providers in Washington who are offering care to out-of-state residents. And that's where I think Legal Voice is really uniquely situated. After Dobbs versus Jackson Women's Health Organization is decided, I think it's really well, most scholars agree that abortion will no longer be so much of a federal issue or even a state issue, as it is a regional issue, as you have pregnant people crossing state lines to access care. And Legal Voice is the only legal advocacy organization in the country that does this work that is regional. So for example, we are doing work both in Idaho, where the action is taking place, and in Washington, which will be absorbing, will suffer many of the consequences of what's happening in Idaho. And so it's a horrifying time, but it's also an exciting time. And so I'll stop there, but that's a preview of what we're looking forward to in the reproductive rights world.
Thanks, Kim. Well, I just want to invite, that's a lot of information, and I just want to invite folks to drop any of their questions that they have in the chat box or raise their hand if they have any specific questions. We're happy to try to answer them. And yes, Carolyn. You just want to unmute yourself. I still can't hear you, Carolyn. Okay. You
can hear me.
Yes, now we can. Perfect.
So I was very interested in the coercive behavior bill but I was wondering if you had considered the fact that abuse to animals, pets, is a huge issue, because I'm a veterinarian and I'm involved with One Health, and also dealing, trying to advocate for this, that studies show that 70% of women have experienced threats to their pets and will not leave an abusive situation because of that. And there's a lot of situations where animals have been hurt or even killed in an effort to keep women from leaving an abusive situation. So was that even considered in this bill?
As you might have gathered, because I discussed my dog breathing in my face earlier, I too am a pet lover. And, there's nothing specific in this bill, but I think the language of this definition of coercive control, of course, judges have great latitude in what they consider to be domestic violence and abuse. So there's nothing specific to that question, but I think that could become part of a pattern of other behavior, that along with some other behaviors that are named in the statute could certainly be sufficient to warrant a protection order. I think, and I'm not sure if this is what you're saying, so I just want to clarify that there is also another procedure outside of domestic violence protection orders, which is called a replevin action. So if what you're saying is a survivor may not want to leave because they're going to leave behind the pet, or they've fled and the pet is still there, there is a procedure in the courts where you can seek to get an order to get property back. And I have assisted a survivor a long time ago to get her cat back through that process. It's not, if you have a beloved pet, you don't want to be trying to fight that out in court, but that is another option. And, you know, I think
It's-
you're
it's
right.
more-
If a survivor loves a pet, then that is going to be just a tool that a skilled abuser could use.
Well, it's more like things like, come home or I'm going to throw the cat out the window or stuff like that. That, you know, that abusive controlling behavior before people even leave.
Yeah.
And not so much about getting the animal back, but the way that women, and I say women because that's mostly what it is, won't leave an abusive situation because they know that their pet has either been hurt or will be hurt or killed. And there's so many incidents, there's so many examples of that actually happens. So
yeah, and another thing that is maybe implicit in that is just that, you know, there's a lack of shelter options for folks who have pets, or and so that's, you know, also an additional concern. And we just need to keep, you know, advocating for resources available to survivors that are responsive to the situations that they're facing, including, you know, bringing their pets or going to a hotel or getting some kind of relief for the situation that they're actually in, not, you know, trying to fit them into the resources or the options that the government deems appropriate.
yeah, well, I've been advocating for co-sheltering. It's a big movement across the country, and my senator knows that I've been advocating for that, and there's been some movement in that area. But I don't know if this is an accurate or recent figure, but only 3% of the shelters in the U.S. allow co-sheltering or animals to come in. So that, you're right, that is such an issue.
Yeah.
Thank you.
Thank you for naming it.
Thank you so much for your question, Carolyn. Are there other questions that folks have? I don't see any in the chat box, but feel free again to raise your hand using the hand function in Zoom. And while folks are thinking about their questions, we can kind of move on as well to kind of looking ahead piece. And Kim already kind of started this conversation in terms of the repro work that we're anticipating, in terms of trying to think through progressive policies to expand abortion care, and the hospital merger bill that didn't make it this session. We will definitely be doing that, going back in 2023 as well. And then in the UI bill for undocumented immigrants that Andrew mentioned, that will be one of our priorities again for 2023. Andrew, do you want to talk a little bit more about, or do you want to talk a little bit about the portable benefits piece, locally in the city of Seattle level that you've been really leading on, and that will be continuing in the next year?
Yeah, that's an important campaign that really reflects the power of the domestic workers movement in Seattle and in Washington State, and attaches to our community lawyering approach. But that's a campaign where it's based on this problem that many domestic workers get no benefits at all, especially workers like house cleaners who work, short-term jobs for multiple employers. So under the way the laws are constructed, workers like that, don't get paid sick, because those laws are designed around having one employer and working a whole lot of hours for one employer. Like the Seattle law is, you have to work 40 hours for one employer to get 1 hour paid sick. So those workers don't get that, or let alone paid vacation or other benefits like bereavement for leave. So we're part of a campaign led by our partner Casa Latina. They organize house cleaners, and that approach would provide PTO, paid time off, to workers so that they get this benefit as they move from job to job, short-term job to short-term job. They would earn it as they go from short-term job to short-term job, and also they can work limited hours. They don't have to work a whole lot of hours. Like, for example, unemployment requires you to work 600 something hours over a number of quarters in order to be eligible for that kind of benefit. This would be a low barrier to entry benefit, and that's an innovative approach that's sort of being grounded in the domestic worker community, the gig worker community as well, that's starting to build steam. And so we're part of this innovative effort in Seattle, and we hope that can be a model for eventual state legislation and for growing. It's being tried out in San Francisco and Philly as well. But really, it's a new approach. And one other piece I was just going to mention, Courtney, was the campaign that we're working on, also grounded in the domestic worker movement for workers' comp for domestic workers. And there we successfully worked with Casa Latina again to get a proviso passed in last year's budget that set up a work group. And that effort is to get rid of that exclusion of domestic workers from workers' comp. It's really one of those laws on the books in Washington state still that's emblematic of a racist legacy that's enshrined in our laws that's excluded domestic workers from many basic labor rights since the 19th century, and that continues to this day. So we're working with Casa Latina at the table with the Department of Labor and Industries to craft a policy recommendation to the legislature that'll eliminate this exclusion, and would also allow low barrier entry requirements for domestic workers to get covered by workers' comp. So that's a long overdue effort to eliminate that exclusion that we're working on as well. So we're sort of still grounded in really basic safety net issues in a lot of our work looking forward.
Great. Thanks, Andrew, for lifting that up. Catherine, do you want to talk about kind of the gender affirming healthcare for young people advocacy that you're anticipating in the coming year?
Yeah, thank you. There was a coalition of folks coming together, I guess, late last year to discuss whether or not we felt we had the right language to try and move forward a bill that would allow youth to consent to gender affirming healthcare. And of course, you know, the question that everyone wants to know is, at what age is that appropriate? And so we were talking to doctors and really reading the literature. As you know, this was not the year to try and move forward anything proactive to support trans, non-binary, and gender expansive youth. But it is something that the community is asking for and is concerned about. And I am presenting tomorrow at a regional conference around gender affirming healthcare for youth. And as part of that, folks have been sharing that, you know, gender affirming clinics are being shut down. There's a lot of fear around liability for providing this, you know, essential care. As we saw in Idaho, that, you know, there was a bill to criminalize providers for providing gender affirming healthcare, which typically means just hormone blockers and social support for trans and gender diverse youth. So, you know, a really scary time. But again, just want to uplift that in Washington, I feel like the conversations that we're having around where we want to go and how we want to support our trans siblings, you know, is an inspiration. And much like the Gender Affirming Treatment Act last year, you know, I think Washington is in a position to do some good legislation and, you know, counter the narrative that exists across the nation. So thank you.
Thanks, Catherine. So I don't see any questions in the chat box, and I don't see any hands raised. So I think we'll just kind of close out. Again, we really appreciate you all taking time to join us, you know, on this beautiful, glorious day. And we would love for you to stay involved with Legal Voice and our team. Just a couple ways to do that. You can definitely sign up for our newsletter. You'll get all the updates of our advocacy efforts, including our litigation. We also have like a legislative specific newsletter for those who want to get, you know, action alerts or more detailed updates during the session. We're on social media, you know, Instagram, Facebook, Twitter. So, you know, please, you know, follow us. We're trying to do more Facebook Lives in the coming year. So keep an eye out as well. And then we're bringing back our Pints in Progress after, I guess, 2 years. We're going to be holding those again later this spring, where we hope just to gather in small groups to talk about really like all things policy, all things Legal Voice. So keep an eye out for those dates in May and June, and we really hope that you can come out and join us. So And I think, yes, the first one is May 17th, actually, May 17th in South Lake Union. So again, thank you so much for joining us this evening, to our team and our staff, for all of their leadership and the work and pushing in their advocacy efforts. So thanks everyone. Have a really good evening and enjoy the last few minutes of this wonderful day.